It has started.
Thank you. So just for our new members, we do record all of our meetings. They are available on our website afterwards. We usually get it up within about 24 hours after the meeting's held. So just so y'all know, that way people can see what we're talking about, transparency, all that. So, and we did unfortunately start a bit late today in the recording. It's about 2:07. It's my fault. I forgot to have it started when we started around 2:01. So we already did our roll call, and we're going to be adjusting from the agenda a little bit. So we're going to start with our AG, Mr. Roberts, doing part of our training. Is it slide 9?
Yes, sir. Okay. Slide 9.
Ms. Rusha.
Hey, Mr. Riley. I apologize for being late. I just wanted to note that I was here.
Okay, thank you. And I appreciate that. I did see you. Thank you.
Thanks.
All right, so let me go ahead and get this slideshow going, and we'll go ahead and jump right in. So
let's get this show on the road, Nate.
Exactly. Okay, so hold on. I gotta mess with my screens a little bit here. Okay, let me see if I can just do this. Sorry, little technical difficulties here. Give me one moment, please. Okay, let me try this instead. All right, can everybody see that okay?
Mm-hmm.
Okay. So again, we're going to skip to slide 9, starting with Colorado Open Meetings Laws. Mr. Roberts.
Thanks, Nate. Welcome to the new members. Just so you all know, I am John Roberts. I am an Assistant Attorney General with the Colorado Attorney General's Office. I am your attorney and the task force attorney and your attorney for your purposes on the board. So feel free to ask me any questions as we go along here and as we go along with our task force business. So as part of the training, talk about the Open Meetings Law. The Colorado Open Meetings Law, also called the Sunshine Law or the Sunshine Act, requires that all state business be conducted in the sunshine, which is what I call the Sunshine Law. And we are an advisory committee. Our advisory task force, advisory committees are also popular in DORA, and we are subject to the Open Meetings Law, also known as OML. The Open Meetings Law requires that, as I said, meetings to be in the sunshine, which has a couple of specific requirements. One, it has to be noticed to the public, so we have to tell the public when we're going to meet and what we're going to be talking about in at least general terms. We have to it has to be open, which means we have to allow members of the public to not join our meeting but observe our meeting. And we have to document it, which means we prepare minutes and keep those minutes. for public review if someone makes a Quora request, which we'll get to Quora in a few slides. Moving on to what a meeting is. If you want to move the slide forward, Nate. A meeting, if you all have seen the General Assembly, they like to add definitions to what we all think we understand the meanings of words to be. So they defined meetings as anything in person, electronic, by telephone, or other means of communication, which in our day and age encompasses a lot of platforms, including the one that we're on right now. So this would constitute a meeting. If you are going to talk about public business of the task force in any way, electronically or otherwise, it constitutes a meeting and needs to be noticed. It needs to be documented with minutes. You can see the second paragraph there. I'm not going to go through it. Some things don't include or aren't included in the definition of meeting, like administrative matters, like scheduling a meeting. But if it's policy making business of the task force, that constitutes a meeting. Next slide, please, Nate.
Just real quick real quick before we jump to the next slide. Just
Sure.
a reminder, if anybody has any questions about any of this, feel free to shout out, or you can wait till the end and we can talk about it later. But this is kind of everybody's opportunity to feel comfortable with all this information. Also as a reminder, this updated slideshow will be present on the Towing Task Force website after we're through this training today. So we'll probably put it up sometime before the end of the week. So if some of the letters are too small for you to read or something, it will be available for you to look at later.
Thanks, Nate. And if you do have a question, Dr. Pierce just demonstrated what would be the preferred method of raising a hand. Go ahead, Michael.
Thank you. I'm just super curious, just since we have this towing legislation that could reflect on prices, we could treat it as reflecting prices. If I were to call John Connolly and say, what do you think of this bill? Where are your thoughts? Would that be a meeting?
It's kind of a gray area because it hasn't come to the meeting or hasn't come to this task force for any action, and if it's pending legislation, it's not law yet. My advice would be is that would constitute a meeting because we're a public facing and a public agency, that if it looks bad, it is bad. So if I kind of take a step back and think, what would I think as Joe, Colorado resident who isn't in on these meetings? What would I think about a couple of these task force members chatting about pending legislation that they might enforce? That I might have a problem with that. And if I would have a problem with that as Joe, Colorado resident, I think that would be considered policy making and should be just in a meeting. Okay.
Thanks.
Moving on, I'm on slide 11, Nate, if you want to follow along at home. So a meeting is, as I said, electronic, and it has to be two or more. So like Dr. Pierce just mentioned, if he calls one of the other task members about something, it just takes two to tango, and it just takes two to have a meeting. If we have a meeting, we have to have a quorum in order to conduct any formal action, which, take votes and pass rules or, whatever it is that would be a formal action. We need to have a quorum. And this has been an issue, and thanks Jenny and Ed for joining us, because before you joined us, we couldn't conduct any business for a little while because we were down a couple of members because we did not have quorum. Minutes, that's Nate and Hadija. They put minutes, put them out, and then we vote to approve them or not approve them at the next meeting. Then they become part of the public record. Any questions on this slide before I move forward? Moving on. The big exception for open meetings law is executive session. It sounds fancy. It sounds like something that Congress would do. Executive session just means we get to ask members of the public to leave the room. Back when we used to have meetings in person, we would ask the public to leave the room so that we can discuss a number of things that the statute allows boards and agencies to discuss in private, in confidence. What we do now is, and we don't do it very often with this task force, but just so you know, if we were to go into executive session, we would have a different platform. It's like Zoom or one of the other many platforms that people have meetings about. We would close this down and go to another platform so that we could ensure that our connection was secure and no public was involved. That's how we've been handling it in the hybrid state since 2020. Can't believe it's been 4 years. So we can go into executive session for a number of reasons. The statute, the Open Meetings Law statute, has many bases for boards to go into executive session. Only a couple apply to this body, so I'll only go into them without the other two. One is to confer with counsel. So if you have questions about, if you want to get legal advice, that's kind of what it comes down to. If you want to get legal advice about a statute or a rule or what our options are for anything under the law, anything that would be attorney-client privileged communication, we can go into executive session to protect that, such as, as I said, pending court action or legal advice, like written legal opinions. Matters required to be kept confidential. This would include such things as HIPAA. Documents are protected by HIPAA of a medical nature, and specialized details of investigations that comes up infrequently, but it is something that may cross our path with this body. Yes, Michael, go ahead.
Just to follow up on whether or not identifying information about individuals or companies might trigger executive session. They do in many other contexts if you're talking about specific individuals or organizations.
I think it would be that's a good question. Thanks for bringing that up. I think it would depend on the context. If we were talking about matters that were related with a company or a person that would be proprietary or confidential or financial or something that would be protected under CORA, because CORA, the Open Records Act, and OML kind of work together. So if it's something that CORA would protect, we can't really discuss it in a meeting because it's considered to be confidential by another statute, like the second bullet on this slide. That includes CORA. So if CORA protects something from to be confidential, protects it from public disclosure, that would be something that we would have to talk about in executive session. But it just depends on whether it checks any of the boxes in CORA, for example. Okay, moving on. I'm on slide 13. So best practices for running meetings. We encourage open discussion, deliberation, as it's said here. So open and constructive deliberation, being respectful of each other. Majority rules when it comes to taking formal action, taking a vote. We want to keep our discussions to one topic so that we make a clear record, and two, so that we can have an actually productive conversation. The minutes. I haven't seen any issue with Nate and Adijah's preparation of the minutes. They require the time and place, who is in charge, and all the things that we talked about. And as I said before, quorum. We have to have a quorum to conduct formal business, and that's it's more than one half of the members. So simple majority, put it that way. Moving on to slide 14, ex parte communications. Ex parte means without the other party. That's Latin. This is something they taught us in law school. Ex parte communication, it happens when one party gets to talk to an agency or a towing task force, for example, without the other party being present. Like I represent a number of programs in other divisions of DORA, and we deal with complaints against licensees, like a complaint against an engineer. In that case, an ex parte communication would be allowing the complainant to appear and speak to the board without the respondent, the licensee, being there to voice his or her opposition or position. So if we just listen to one side, that's ex parte communication, and that's bad. We're not gonna be able to do that. Because it creates prejudice. So we have to give everybody their due process, which in short, in the Constitution, means a right to appear, notice and appeal. Any questions on ex parte communication? Sweet, moving on. Ex parte communication with PUC commissioners or staff. My advice about this is don't reach out to the PUC commissioners or the staff, because that creates an ex parte communication. The commission and the staff that supports the commission, they are the decision makers. So it would create ex parte communication for this body or any one of you to, or any one of you, not the whole body, to reach out to the commission or its staff. Nate, do you have any comments on this slide? This is a new slide, and I'm just make sure that I hit all the important parts before we move on.
Yeah, I mean, yeah, I think you mostly covered it.
Okay.
Again, it's just that whole appearance of impropriety. So, like John, you said earlier, if it feels wrong, it probably is. So
yeah. Okay, thank you. Good. I just want to make sure there wasn't something else that you wanted to hit. Next slide, which is 16. If you have ex parte communication, so the takeaway from this slide is if you have any ex parte communication, let's say that a member of the towing community knows that you're on the task force and they reach out to you about something that they are involved with, and you have a correspondence with them. You have a email correspondence or text communication or telephone communication or fax machine, whatever it is. If you have a back and forth with someone in the public about a task force policy matter, the proper way to handle that is to disclose it. And you can disclose it by contacting me in advance of the next meeting, or soon after you have the communication, and say, hey, I had this conversation with Joe towing industry member, and what should I do about it? And my advice likely is to be, if you said anything other than, I'm sorry, Joe towing industry member, I can't speak for the whole task force. Please reach out to our program director, Nate Riley, to get on the agenda. If you say much more than that, my advice is going to be, you're going to have to recuse if and when the task force ever considers something to do with that individual or that matter. Okay, slide 17. Conflicts of interest. So conflicts of interest are, I'm gonna take a couple of these slides together just so we can move it along a little bit. Conflicts of interest fall into basically two buckets, two categories. One is actual conflict of interest, where you have a financial interest in a matter to be decided by the agency that you're part of, so this task force. There is also, because we're a public agency, apparent conflicts of interest. So an apparent conflict of interest is, like I said earlier, if it looks bad, it is bad. So you you don't have a financial interest, for example, you don't have a financial interest in a towing company that that the board is looking at, but you go way back with their owner or their CEO, or you attend your kids' soccer practices together, that kind of thing. If it might look bad, if it's on the front page of the Post, if we were still getting the paper these days, then it is bad. So I would encourage you to be cognizant of appearances as well as actual financial interest when it comes to looking at potential conflicts of interest. Slide 18 summarizes the statute about a conflict of interest performing an official act which may have a direct economic benefit, or which you have a direct financial interest. I think I already covered that one. Sorry about that. If you have a conflict of interest, whether you have an actual conflict of interest or you think you might have a conflict of interest, the best thing to do with that is to disclose it. You can either disclose it at the meeting, or you can raise your hand and say, hey, before we get too far into this case or into this matter, I need to disclose that either one, I have a conflict. If you know you have a conflict, you can just say, I have a conflict and I have to recuse. It's called recusing from the discussion. I have a conflict. I can't participate in this one. I'm going to recuse. If you aren't sure if you have a conflict, you can say, hey, at the meeting, you can say, hey, this is my situation in relation to this person, this towing company, or whatever it is. And you can tell us, and then I will give you legal advice right there. I'll do what's known as a voir dire in court. I'll ask you some questions about what your conflict is, or why you think you have a conflict. And then I'll ask you, if I don't see a conflict, I'll ask you the ultimate question of, can you be objective? And if you can be objective and you don't have an actual conflict, and I don't see in my judgment that it looks bad, an apparent conflict of interest, then I will say, you're okay to stay. Thanks for bringing it up. And we'll just move on. Or I'll say, thanks for bringing it up. I think you need to recuse from this discussion. You can also reach out to me in advance of the meeting, and we'll have the same kind of conversation, and we'll just get to the bottom of whether you have enough of a conflict that you need to recuse. Moving on to the Colorado Open Records Act. The Open Records Act has as its overarching purpose of making all public records, which is a very, very long definition in the statute about what constitutes a public record, that all public records are open for inspection to the public unless they meet specific exceptions. So what we do is we look at documents when there's a CORA request. We look at documents about whether they meet any of those specific exceptions. If they don't, we provide a copy, or we make them available to be viewed. Slide 21. Public record, like I mentioned, has a long definition, and it is all contained in paragraph 21. And what's key about this, one of the takeaways is any writings, which is anything electronic or on paper, if any of you remember what paper looks like, anything that's a writing of any kind, photographs, recordings of any type. It's a very broad definition. And if it's created by the agency, or the agency comes into possession of it, and it doesn't meet an exception under the Open Records Act, it needs to be disclosed to the requester. I want to direct your attention to the paragraph at the bottom of this slide about what this means for you. And it applies to all these kinds of documents, paper records, if you keep any of them, electronic records, emails, etc., that discuss task force business are subject to a core request. So if we get a core request that would include a request for members' notes or recordings, we'll be reaching out to you for those. Slide 22. Anyone can make a request for your records, for the commission's records, or any agency in the whole state for their records on anything. They don't have to say why. They just have to identify what they want and be reasonably specific about the dates. And like I said, we can only withhold documents if they meet an exception. And there are, I'm moving on to the last slide. That's mine, and then I'll turn it over to Nate, and I'll duck out for a little bit. There are two categories of exceptions that agencies can withhold documents. One is, so I call it the must and the may. It's funny that this slide is like this, because that's how I've always thought about it in 25 years of representing agencies. There's the must and the may. So there's a category of types of documents that the custodian must deny inspection, and there's a category where it's more discretionary for the custodian of the record to deny. If you're interested if you're more interested in what those details are, I'm happy to point you to the Open Records Act, or talk about it offline, give you some ideas about what the must and the may categories are. But CORA is a very broad statute that encourages and basically mandates disclosure of documents unless it meets an exception. Any questions on anything, slide 8 through 23, or 9 through 23, I should say. Michael, go ahead. How did I know you're going to ask me a question, Michael?
I'm really curious about the towing legislation that's working its way through, and the extent to which we have any room to discuss it with other people. I'm thinking about talking to Representative Basenecker, who's the bill sponsor, talking to folks at the Community Economic Defense Project, who I think wrote much of the bill, and just really worrying whether we have, whether we're basically forbidden by these rules from having those discussions without doing it largely as part of a noticed meeting.
Good question. I would say that you're not prohibited from having those discussions. I think it would be incumbent on you as a member of the task force to disclose to the other members if you've had conversations with bill sponsors about it. I think it's because it crosses into the line of possibly task force public business, that the other members are entitled to be aware of that. And I'm gonna throw it to Nate. I'm gonna step off, but I want to see if Nate has anything to say about that, because I know agencies like this agency, this task force is subsumed, within the Public Utilities Commission, and I know that other divisions within DORA, the PUC is in DORA, other divisions within DORA have policies or best practices when it comes to board members or task force members speaking on legislation. And I'm going to let Nate speak to whether the commission has any policies around that. I'll be back in about 10 or 15.
Thanks, Mr. Roberts. So going off of your question, Michael, I think the way I look at it, because I'm familiar with the legislation you're talking about, and I'm somewhat restricted in what I can say about legislation just based on department policy. But one thing I would mention is it seems like your concern is that what they're currently exploring in the current legislative session regarding towing may have some direct or indirect effects on the task force and what our responsibilities are. I guess the way I've been looking at it is you kind of have to ask yourself a question, which is, okay, is what they're discussing or considering over at the legislature dealing with what amounts can be charged, or is it more about like whose responsibility it is to make those payments? Because I do think that's a pretty key distinction in that, you know, our charge pursuant to the statute is to make sure we are properly advising the commission on what are appropriate maximum rates for towing services, which then, you know, the commission takes into consideration and potentially may amend its own towing rules, which cover what the appropriate maximum rates are for different tow services. So that comparative to, oh, maybe it's the vehicle owner's responsibility to pay those fees, or oh, maybe it's the property owner's responsibility to pay those fees. That seems like a different question. So I think we can continue to talk about this as it goes through. But yeah, those are kind of the comparisons that I'm drawing.
Okay, so just to follow up real quick,
Sure.
one of the things that I would really like to talk to them about is whether or not there are charges that are like tickets. Because right now in the bill it says landlords basically are on the hook for the cost. And if I were to call up them and say, hey, well, what about, you know, adding in some price for the person who's towed to pay, and recommending to the sponsor that they include something like that. I see a hard time doing that without introducing a price tag in there, and in which case it might be under our purview.
Sure. No, I understand. Okay. I think we could talk about that some more. Let's go ahead. There's only 8 other slides besides what Mr. Roberts went through in this training. So I say we just go ahead and finish it out. I handle the other 8 slides, so I think we can get through them fairly quickly, and then we can kind of revert back to our agenda. And I know we've gotten a little sidetracked, and some people are waiting to talk to us, and I appreciate your patience, but I don't think it'll take us too long to get through these other slides. So again, this is the annual training that we do. So again, we do it every year. We try to do it kind of towards the beginning of the year, so people could kind of see it coming. But yeah, we basically go through everything Mr. Roberts talked about, all the kind of the legal side of things. And so here's the list of things, some of which we already talked about. So we talked about the Colorado Open Meetings Law. We talked about best practices in running meetings, ex parte communications, conflict of interest, and CORA, of course. So the other items here at the front end is what I'm going to talk about, and we'll just go ahead and go through it. So first of all, the overview of the Public Utilities Commission and what it is. So the PUC is an independent administrative agency within the Colorado Department of Regulatory Agencies, or DORA. So DORA is our department. We're one of about a dozen or so different divisions within that state department, which is part of the executive branch. And the PUC regulates a variety of things that can or are considered to be public utilities. So transportation is what applies to us here. So we regulate at the PUC most types of what we call intrastate for-hire transportation. So basically point-to-point within the state in a variety of different industries. So some of the industries we regulate are taxi cabs, for example, limousines, shuttles, TNCs, which is the Ubers and Lyfts. We regulate them as well and have for about the last 10 years. Towing is another big one, which is obviously tied into what we do here. Moving, and we've also recently started regulating vehicle booting companies as well. We also have some other types of limited regulation carriers like ORC, CAB, and CSB, which is charter buses, off-road scenic charter, children's activity bus, things of that nature. PUC also regulates other industries in the safety realm, which is rail and transit safety, gas pipeline safety. I know a lot of people have been talking about gas as an energy source lately. Energy, gas, utilities, telecommunication, water. We do research and emerging issues as well. So yeah, it's quite a bit that the commission does. Moving on to how the commission is set up. So basically, there's 3 commissioners that essentially make all the decisions. That's kind of how things are set up. These commissioners are appointed by the governor for 4-year terms. They are confirmed by Senate vote, like a lot of other high-level positions. And there is a standard through which no more than 2 commissioners on the bench at any given time can be part of the same political party. So you might have 2 Democrats and an independent, or 2 independents and a Republican, whatever the case may be. The PUC does, or the commission specifically does have a variety of subject matter experts in its commission staff. So all these different teams, all the industries I just listed, and that are available here as staff, contain experts in the various fields. So we have a lot of energy experts, people who are, from the telecom industry, transportation, which is myself and our transportation section staff, rail transit, gas pipeline. They also have policy advisors, like I mentioned earlier, research and emerging issues, strategic communications. Consumer affairs is big as well. They're the ones who take all our complaints. So basically, it doesn't matter which industry, which field. If they have a complaint, if they want to complain about their energy or gas bill, or if they want to complain about a towing carrier, they all reach out to Consumer Affairs. That's kind of the funnel through which all complaints and concerns and things go into. Our commissioners currently are Tom Plant, Eric Blank is our chair, and Megan Gilman. Those are our 3 commissioners. I included some pictures there for you. These are also on our website as well. And our PUC director is Rebecca White. She started back in May, and she's doing a great job so far. Moving on to the PUC's regulation of towing carriers. So the PUC does have authority to regulate pretty much all types of towing carriers that operate in the state. We derive that authority through 4010.1401, and really, the 4010.1 statute in general covers a lot of our ability to regulate all these different industries. But specifically 401 does require a towing carrier to obtain a permit from our office and follow all set requirements and conditions for that permit in order to legally operate. We also have our rulemaking authority, which is under 4010.1106, or at least that's one of our rulemaking authorities, which allows us to prescribe rules. For towing specifically, it references circumstances under which a tow may be performed as a non-consensual tow, so without permission from the vehicle owner. Also, the responsibilities for care of a towed vehicle, and also the minimum and maximum rates and charges to be collected for non-consensual tows and storage of a towed vehicle. So basically, when you round all those state statutes together, we regulate what I refer to as the 3 primary types of tows, which is consensual tows, which is your standard, I broke down on the side of the road, I need to be towed to a mechanic, AAA, those styles of tows. Non-consensual, which is what we deal with a lot here on the towing task force, which is towing without the person's permission from private property. So basically somebody's parked where they're not supposed to be, they get towed there at the request of the property owner. And then law enforcement ordered tows, which is primarily public property tows. So that's your basic, post-accident, post-arrest, those types of situations. So yeah, those are the 3 primary categories of tows. We have different levels of regulation for each category. Consensual is the least regulated, but we do still require them to be permitted and insured. We did adopt rules for transportation carriers, including towing carriers. Our general rules are under our 6000 series, so those apply to a lot of different types of carriers. So, for example, our insurance requirements are under there and some other things as well. But then we also have rules that are specific for towing, which is the 6500 through 6514 rules. Moving on to the overview of our body here, the Towing Task Force. So the Towing Task Force is an advisory committee, as mentioned by Mr. Roberts. It is created within the department, which is DORA. As of November of 2021, the Towing Task Force consists of 14 total members. Each are appointed to either 2 or 4-year teams. It actually used to be 9 members when it was first originated back in, it was either 2014 or 2015. And they essentially amended the way the task force is set up and added the new membership positions as part of, I think it was HB 21-1283 back in 2021. So it added 5 new positions, some of some of whom are here at the meeting, filled those positions. And the statutory requirement is that the towing task force meets at least twice a year. Usually we far surpass that. But yeah, that's the statutory mandate. In regards to the duties and powers that we have, basically our primary duty is to make recommendations to the PUC about tow rates and essentially what they should be for non-consensual tows. So specifically, we're tasked with making comprehensive recommendations to the PUC about the maximum rates for the recovery, towing, and storage of a vehicle that has been towed without the owner's consent, so a non-consensual tow. Towing Task Force it was required to make its first comprehensive recommendations to the PUC back on July 1st of 2022, which later got amended to September 1st, 2022, but then got later amended to November 1st of 2022. This group did meet that deadline, and that report was filed, but I think we were interested in putting together some subsequent reports moving forward. The state law also instructs the PUC to consult with the towing task force when issuing or amending rules concerning the towing rates. So we would essentially be looped in some capacity to if there was a pending rulemaking, for example, at the PUC that addressed specifically what the rates are. And then finally, we also have the duty and power to make recommendations about investigations of overcharges. So the towing task force is to advise the PUC or the PUC staff concerning investigations of overcharges by towing carriers. The statute does direct at the discretion of the commission for PUC staff to consult with the TTF regarding those specific types of investigations that they see from time to time. And then finally, the towing task force is tasked with analyzing and making recommendations to the commission about non-consensual towing rates that are charged to the public, taking into account current consensual towing market rates and their relationship to non-consensual towing rates. So the way rate regulation works here in Colorado is non-consensual tow rates and law enforcement ordered tow rates are regulated, and there are maximum rates in rule at the commission. However, consensual tow rates is pretty open market. So I think that was the intent of the legislature, is to have us just kind of factor that in when we're doing our analysis. All right, I think that does it for our training. Any questions on anything that I covered? Okay. All right, well, thanks everybody again for your patience. I know we went a little out of order to start today, but I appreciate everybody's patience for that. Just a quick few things before we kind of dive into our general discussion. I did want to go ahead and suggest approval of the minutes from our last handful of meetings. As listed in our agenda and some of our filings that we circulated prior to this meeting, our minutes that were populated for the September 13th, October 11th, November 8th, and December 13th minutes still have not been fully approved. In a lot of cases, since we were some members short, we just weren't ever in a situation where we had a quorum available to go ahead and approve those. However, I do believe we have one now. Let me just double check real quick. 1, 2, 3, 4, 5, 6, 7, 8 is exactly the number we need to do it. So we do technically have a quorum right now based on our membership. Again, there's 14 total members. 3 are still vacant, but 8 is the minimum for a quorum. So we do have a quorum present. Do we have a motion to approve those 1, 2, 3, 4 sets of meeting minutes that were previously circulated?
This is Jim Howes. I'll make a motion to approve the minutes from the prior meetings.
Okay. Howes has put forward that motion. Do we have a second?
I'll second it.
Second.
Oh, sorry. I heard 2 people at the same time. Who is it? Is it? I think it was Brandon or Michael. Which one do you want to claim it?
I think both of us did. I don't
You can
care.
let Michael have it. You can let Michael have it.
Okay. All right, Michael. Thank you very much. Okay. For minutes, we typically don't do an official vote. We just see if there's any objections. Do we have any objections from the current members present to approving all 4 of those sets of meeting minutes as presented?
Aye.
Okay. Hearing none, those minutes are approved. Thank you very much. Okay, so let's go ahead and move on to our administrative items. And I'd like to start by thanking excuse me, hold on. Sorry, I want to thank the patience of Brian Tobias. Brian Tobias is the director of Hopper, and he is here to share some things with us. So, Mr. Tobias, would you like to introduce yourself and let us know what's on your mind?
Thanks, Nate, and thanks everyone for allowing me to come join you this afternoon. I didn't know it was going to be a civics lesson today, so I'm going to add to that a little bit, I guess. I'm the director of the Colorado Office of Policy Research and Regulatory Reform, the mouthful. So as Nate said, we call ourselves COPPR. But my office conducts all of the sunset reviews in Colorado state government. We are housed in DORA, but we're actually part of the executive director's office. So I'm not part of the PUC structure that Nate was describing to you earlier. But I asked Nate if I could come and speak with you for a few minutes here this afternoon about a couple of sunsets that are very relevant to the task force. One is the task force itself is under sunset review, as well as the PUC's regulation of towing. And those are going to be conducted under two different statutes. But just to give you some background, sunset reviews are triggered by a clause in the statute that creates either the regulation or the task force in this case that says something to the effect of this statute is subject to repeal effective September 1, 2025. Prior to such time, it shall be reviewed in accordance with, and then there's a reference to either Title II or Title 25. I'm going to talk about the Title 25 sunset because that's really the big one, and that's the sunset review of the regulation of towing. The General Assembly has given us 14 criteria that we use when we look at programs. Really, we're looking to see, is this regulation necessary to protect the health, safety, and welfare of the public? And if it is, does it represent the least restrictive form of government consistent with the public interest? And the other criteria really flow directly from those two questions. We engage in a lot of research, and a lot of our research entails stakeholder engagement. We try to solicit as much diverse input as is practicable. The whole idea being the more diverse the more diverse the input is at the beginning, the better the public policy is at the end. So nobody ever has to wait for us to contact them to participate in any of our reviews. As task force members, I will be reaching out to each of you as your individual capacity to get your thoughts on both the regulation of towing as well as the task force. But all of that research, will culminate in a report that comes out on October 15th. That report will recommend one, to continue or sunset the regulation of towing. And if we continue it, whether the General Assembly should make any additional changes to the statute. Those recommendations will then be put into the form of a draft bill that we will present to the General Assembly in the 2025 legislative session. And sort of taking another step back, the task force itself is also under sunset review. It's under a different statute. It's a much more limited statute. But regardless, I will still be doing the two of them in tandem. So you really won't see a whole lot of difference in terms of the kinds of questions that I'm asking about the two. Still results in a report that comes out in October. We will recommend either to continue or sunset the task force, and that will be put into the form of a draft bill for the 2025 session. That's sunset in a nutshell. I didn't have a lot of time on the agenda, so I don't want to get too far into it. I know you have a lot to talk about today. I'm happy to answer any questions if you have those about the process. Otherwise, I will just sort of be fading into the back and observing. I will put my email address in the chat here as soon as I'm done speaking, so that if anybody wants to reach out to me before I reach out to you, you're certainly welcome to do that. And thank you very much.
Thank you, Director Tobias. Really appreciate you being here, and again for your patience in getting to your part of the agenda. Sorry we had to jump around a little bit, but definitely appreciate your patience and you letting us know what's going on. So thank you very much for that.
Thank you.
All right, kind of continuing with some of our administrative items. Just a reminder to everybody, especially for the newer members of the task force, we are required as part of that annual training that we just took to fill out affidavits, just basically indicating that we have participated in that. Basically, what it all boils down to is, were you privy to the training and the substance therein, as well as were you given the opportunity to ask questions? So as long as you meet both of those criteria, it should be okay for you to go ahead and sign those affidavits. We'll be circulating them. Hadija will probably be sending them out to you in the very near future. Oh, thank you, Brian, for sharing that chat. So there's his email address if anybody wants to write it down. Otherwise, it sounds like he's going to be reaching out to us as well. So thank you for sharing that. But anyway, to my point, Hadija will probably be circulating those affidavits here in the very near future. So when you see them, if you could just go ahead and review it, and if you're comfortable with everything on there, go ahead and sign it and return it to us, and we file it with the department. So I would definitely appreciate all of you. Thanks in advance for doing that. Moving on to training, or while we're on the topic of training, some of you may have also received some emails regarding OIT style training. I know I got an email, it was probably like late last year. I forget which month it was in, but basically, I guess the department wanted us to engage in some kind of a OIT training. It's something I'm familiar with. Just it seems pretty similar to the other trainings that I take as a DORA employee. But yeah, it was pretty simple. You just signed up for an account, which was fairly simple, and then I think it was like 15-20 minutes long. So a few different sections to go through, and it just talks about various OIT and cybersecurity related features and topics. So if you've seen those, I would encourage you to go ahead and make sure you're doing those. There was also an email that some of you may have seen back on within the past week. I think it was on the 22nd, or at least I think I got mine on the 22nd. It was an email also from our department regarding the use of state email addresses. So everybody in this on this body should already have a state email address that they can use. I would just echo what that particular email said, just encouraging you to use that email and that email only in regards to Towing Task Force business. It's just the cleanest way to go about it, and does not open up you up to any additional risk of using your personal email addresses for TTF related business. So I would definitely encourage everybody to do that. Moving on to, I know Dr. Pierce made mention of pending legislation and concern that he had about it. I also just wanted to float House Bill 241168 as well, just to kind of put it on everybody's radar. It has to do with the different boards and commissions. It's not exclusive to the TTF. It's more of a across every commission and board style legislation, something about equal access to public meetings. So that may end up having some kind of a direct or indirect effect on us, depending on what the bill ends up being and if it even passes, first off. But obviously, it seems more administrative in nature, but I just wanted to float it out there just so everybody's aware of it in case you wanted to look into it yourself. Again, that was House Bill 241168, but it seems more about just making sure that we make our meetings as available as possible. So it may lead to us having to make some adjustments on how we do our meetings moving forward. But again, we'll just kind of wait and see what happens. And that's, I think, most of the administrative updates I had. So going back to the agenda, we already did our approval of the minutes. We did our administrative, we did our annual training. So now I think we've gotten to the point on open discussion. So we can kind of just see what everybody wants to talk about. I thought we might start with our newest members, Ms. Henson and Mr. Schoenheit, to see if, I know we gave you, a brief introduction earlier, but, if you wanted to tell us a little bit more about yourselves and kind of what your thoughts are on the task force and, what you hope to bring to it and, any ideas you might have, definitely be interested. Ms. Henson, do you want to start?
Sure. Yeah, I'm happy to be here. I'm excited to sit on the board with you guys and to have an opinion and to learn as much as I can. I've been in the towing industry for 8 years now. I own a towing company in Grand Junction. We do non-consensual towing and we do normal towing too. We do both consensual and non-consensual. We are, I think, the biggest non-consensual on the Western Slope. So we do a ton of it. So I'm definitely excited to be here and to learn and have some input. I don't really know what all this consists of, since it's my first time being here, and yeah, that's about it.
Thank you for sharing. Yeah, no, definitely glad to see the input on the Western Slope. We definitely, you know, with the recruiting for this particular body, I know we always try to expand beyond just the Denver metro area, and even further beyond, you know, beyond El Paso and other places as well. So definitely glad to have you here and give us that perspective from the other side of the mountain range.
Yeah, I think our city's a little different too than Denver. Like we're kind of in a strange spot, so it's kind of good for us to have a say over here. We're kind of a little bit in the middle of nowhere, but we are a big city. So I think the issues are a little bit different from the Denver metro area. So it's nice to have a say so over in these parts.
Of course. Just to interject real quick, two things. First off, I'm going to go ahead and post the link to our website. So this is the Towing Task Force specific website that I mentioned earlier.
Okay.
This is where I'll go ahead and update that member training. There's a link there under additional documents. This also has, you know, various things. This is where we put the notices for our meetings. This is where it lists all the membership. So all of us, including our two newest members, should all be on this list, including what particular role they are filling. So that's all on here. Links to previous meetings, if anybody wants to go back and look at some of those recordings. If you missed a meeting, or for our new members, if you want to go back and see kind of the flow of where we've gotten to. Again, we record every meeting, and we even record our work groups that are subsets of our overall group. When we were doing our report back in 2022, we have those as well. Agendas and minutes are all there. Other documents, everything's there, including the Towing Task Force report that we submitted back in 2022. That's also under additional documents. So for our new members, if you want to go back and look at what was included in that report, that is always available to you and anyone else who wants to look. So that's all there. The other thing I forgot to mention earlier, we do still have 3 vacancies on the task force. So we currently have 11 members filled. Yeah. So of the total 14, we still have 3 that have not been filled yet, but we have leads on backfilling those as well. So hopefully we'll see something in the near future and get up to the full group. But yeah, it is unfortunately somewhat difficult to recruit for this task force. It's hard to find people that want to contribute the time, because it is a volunteer exercise, and also people who can fit into these pre-established roles. It is quite difficult to recruit for. So, but we're working on it, and hopefully we'll get those other 3 membership roles filled ASAP. Okay, well, thank you, Ms. Henson, for sharing. Definitely appreciate you know, your thoughts and your comments. Mr. Schoenheit, anything to add?
Yes, I just to give you a little bit of background. So as far as you know, I'm a senior board member of the largest HOA in Colorado Springs, over 3,000 houses, 700 acres, consisting of you know, public streets and private streets within some of the sub HOAs. I've got a fair amount of experience with towing. I was a police officer 30 years ago. I know that seems kind of crazy, but did a lot of towing back on the East Coast, non-consensual tows, accidents, DWIs, criminal activity, and there's obviously a lot of traffic and a lot of vehicular activity going on. So a lot of tows going on the East Coast for all sorts of reasons, but definitely had a lot of experience with those type of operations within Colorado Springs. Understand a lot of challenges that our local law enforcement deals with towing. And then with our own community, when we deal with abandoned cars, stolen cars, disabled vehicles, and things like that, complaints that residents have, as well as some of the things that some of our private HOAs and some of the owners there deal with some of the issues that come up with non-consensual towing and things like that. So pretty fair and balanced. Understand a lot of challenges across the industry. It's obviously a critically important function to have a vehicle recovery and be able to tow vehicles when you need to at accident scenes and things like that. So I've been keeping up with some of the legislation that's working its way through the Denver Assembly right now, and understand kind of some of the ins and outs, and was asked to serve on this advisory commission by one of the organizations that I'm a part of that represents HOAs and metros within Colorado.
Great. Well, we're happy to have you here. Thank you for joining us. Also, just wanted to say real quickly, congratulations on obviously our new appointments, Mr. Schoenheit and Ms. Henson, but also the reappointments of members John Connolly, Michael Pierce, and also myself, which was all part of that appointment back in January. So definitely appreciate everybody's continued participation and service to this, and look forward to some good things moving forward. Okay. Well, yeah, that's most of what I had pre-planned to discuss and talk about so far during this meeting. We're a little over an hour in. We do plan these meetings just for the benefit of our new members. Our typical schedule is usually the second Wednesday of every month. That's kind of the standard schedule that we've had for the most part over the past 2 years. So we deviated a little bit this month. We actually didn't. We ended up canceling the meeting that we had scheduled for January because we were expecting our new appointees and obviously our reappointments. So we went ahead and canceled our January meeting, and then just the way the time lined up with onboarding our new members, it didn't work to get it in by February 14th. But I think we can go ahead and if everybody's okay with it, we can switch back to that kind of cadence for meetings and stick with that second Wednesday of every month. So Wednesday 2 p.m. is usually from 2 to 4 is our standard meeting time, just so everybody can kind of anticipate it, months and months ahead, so you can kind of plan around it. I'm comfortable doing that. I hope everybody else is as well. If you have any objections to that, just let me know. But that would put us on track for a March 13th meeting next. It's a shorter turnaround this month just because of what I mentioned earlier. But then that would then move to April 10th, May 8th, June 12th, July 10th, August 14th, September 11th, October 9th, November 13th, and December 11th for the rest of the year. So unless anybody has any objections to that, we'll just go ahead and plan on that. But yeah, that's kind of, I think, going to be the cadence moving forward. Again, short turnaround over these next 2 weeks with this meeting, and then the one that we'll go ahead and schedule for the 13th. But it'll always be that second Wednesday of the month, starting at 2, going as late as 4. But we don't always use the entire meeting time. It just depends on how many people are here and what all we want to talk about. But yeah, definitely looking forward to hearing some people's thoughts. So that's really all I had for today. I don't think we had any. Hadija, did we have anybody sign up for public comment?
No, we do not have anyone signed up for public comments.
All right, thank you.
Okay.
Just so everybody's aware, I know people who have been around a while are already aware, but Hadija Abdirahman, she is our kind of administrative help for the task force. So she's the one who schedules the meetings and helps with the minutes and updates the website and all of that stuff. So if you ever need anything kind of more on the administrative side of things, feel free to reach out to her at any time. You can also reach out to me if you want, but it's better to reach out to her. So if you ever have any questions or anything. Yeah, Jim.
So our next meeting will be March 15th, Nate?
13th.
13th. Okay. I just wanted to confirm our next meeting. All
Yeah.
right.
Yeah,
Thanks.
it's again, if we want to, again, just kind of, it's kind of a short turnaround with having a meeting today and then having another one in 2 weeks, but then we'll kind of settle back into our once a month, which has kind of been the standard over the last 2 years. So again,
Okay.
it's just how it happened to shape up due to the reappointments and getting our new members on board and all that. So I don't imagine we'll probably deviate from it once we settle back into that once a month. But yeah, for this particular 2-week period, it's a kind of a quick back-to-back.
Okay.
So, but definitely appreciate your feedback on that.
All right. Thanks. Thank you.
All right. Well, if we don't have any public comments, again, we got through the training, we've done all the administrative updates and all that. So now it's just really whatever anybody wants to talk about. So anybody have any thoughts on anything? I know this is kind of more of an administrative, with the training and everything else. So we're just, knocking all that stuff out. But, anybody who wants to talk about anything of substance, we're ready. Mr. Schoenheit.
So I did want to ask specifically if with the current legislation that's going on, if any of the input from the towing task force was going to be included in that for that draft bill that's in the assembly right now.
So I assume you're referring to HB 24-1051. That's kind of the more prominent one that's out there right now. It's I'm sure you've seen news articles and stuff about it. It does hit on some pretty big ideas and concepts. As Mr. Roberts, are you back?
Right here.
Okay, thank you. So as Mr. Roberts indicated earlier, I don't know that there's anything really that prohibits us from, discussing pending legislation. However, again, I think we just have to, tread carefully first off, but also, just try to figure out if what they are the concepts and ideas they are exploring as part of that bill are ones that actually impact us and what we're doing. I know there's been instances in the past, HB 22-1314, for example, where they specifically amended our own statute under 4010.1403 of this body. And so in that instance, it was, I think, totally appropriate for us to discuss the impact such changes would have on how we operate, because in that instance, it actually changed some of the stuff we were supposed to be looking at. So of course, that's appropriate for us to discuss and talk about. But I guess I have yet to see much in that bill that would really impact what we're doing. Because again, when you talk about the fact that we're looking specifically at what we feel is appropriate for the commission to put into rule for what towing carriers can charge for certain services. I mean, I get maybe some indirect impacts, but I'm not really seeing many direct connections.
I guess my impact would be is if they're changing the paradigm to where the person that requests the tow pays that charge up front, whether that's a private citizen or whether it's a HOA or Metro or some other organization, private property owners got a tow, they got to pay that up front. So then that tow carrier has to change the way they do their billing potentially, and also increase their costs. So it's completely changing the whole paradigm on how, I believe, and correct me if I'm wrong, from the SME with the business is, Mrs. Henson is changing the paradigm on how tows are paid for. Usually if you're breaking the law, you've got a disabled vehicle, whatever the case is, it's your vehicle, they're towing your property, you're responsible for that charge. And so now they're changing it up, completely 180 degrees and making the person that's being, I guess, inconvenienced or, injured by that vehicle, and I say word injured as is suffering some kind of, issue with that vehicle being on their property or something like that, now responsible for that. So it seems like that would fall within the purviews. Now we're looking at rates and towing rates. Well, if they're changing the paradigm on how the fees are being charged, then automatically would then go to the cost structure and things like that. So that's kind of how I saw it.
Well, and you do make a point about, how much time or effort a towing carrier would have to expend to adjust to this new paradigm, in which case that could have a correlation to, the rates that they feel are appropriate for the commission to allow them to charge for certain types of tows. So I guess I do see somewhat of a connection there. Yeah, go ahead, Michael.
Thanks. So I wanted to echo Mr. Schoenheit's response that this completely flips it from the charge being entirely on the person being towed to now the landowner who's basically scheduling the tow. And we had spoken about this prior, and at least my recommendation is that it's a shared expense rather than one versus the other. And so I was hoping that we might be able to talk about that as a possible alternative. The other thing is that there actually is a change in how we do business, and that is that there's a requirement that members of the task force recuse themselves from any votes in which they have a financial interest. And so, Ms. Henson and Mr. Connolly would have to recuse themselves from votes on recommending any rates. So I just wanted to flag that that is part of the bill.
You know what? Yeah, no, you're totally right. I forgot all about that part of that bill. Yeah, no, you're correct. They did make an adjustment, or at least in the current draft form, I believe there is an amendment to 4010.1403, whereby, yes, as you indicated, if I believe it was two parts. The first part was basically if somebody potentially had a chance to gain from a recommendation, that somehow would not be an appropriate thing for them to vote on. And then also, I believe the second part was if it was part of some kind of an investigation, which is the other half of our mandate to advise on investigations for overcharges. Similarly, they would need to recuse themselves from that. Mr. Roberts, I mean, I know we didn't really go too deep into the adjustments they made to the 4010.1403 statute as part of HB 221314 2 years ago, but this one seems a little different to me in that it's actually potentially could cause an impact to the voting rights of our membership. Is that, I mean, how do you feel about that? Is that something we should be offering feedback to the legislature about? I mean, how would we even go about that?
That's a good question. One, I have to confess, I have not seen or reviewed the bill. So I'm speaking from kind of in the blind over here about that. But if there is a provision that allows boards to act despite someone having to recuse, and that allows, it's called the rule of necessity, and it allows a conflicted member to participate as if they don't have a conflict. It's kind of like the conflict of interest Band-Aid. So what we would have to do is if by those members recusing, the task force loses quorum, we could invoke the rule of necessity, and Mr. Connolly and whomever else, Jenny, would have to, Ms. Henson, I apologize, would recuse, but then they would be able to make motions and second and deliberate and vote as if they did not have that conflict. That said, if we have quorum, they can just recuse and not participate. But there is that rule of necessity possibility.
Even if such a invocation of that standard would conflict with a different statute that basically says the exact opposite?
Are you referring to the bill that's going through right now?
Yes.
Okay, so that one I do not know. I would need to look at that and balance it and compare it with the rule of necessity.
Okay, it's HB 241051, by the way.
HB 241051 is what you said?
Yes.
I got it.
All right, Michael.
I was also wondering. Well, so you brought up the rule of necessity, and so it seemed to me like if the statute directly forbids voting from members that have a financial interest, if the rule of necessity might actually go towards just rejiggering the quorum, so that basically. Now, in order to get to quorum, we have to allow those folks to vote. Rather, the adjustment is in the quorum level. So if there are two people that have to recuse, then the quorum is a majority of
Those left.
12 members or whatever.
That's possible. I'll have to look into that and get back to you at a later meeting.
Seems like that's a good point, Michael. That might be the more palatable solution if that were the circumstance. That makes me very leery of the whole thing. And I mean, I guess my concern is that, I mean, it's pretty clear in the statute that they want each member advocating for a particular interest group or community. Like that seems clear in the 403 statute where it lists our specific roles. So to then go backtrack on that and be like, well, unless this, then
Yeah.
your opinion has no weight. That just, it seems contradictory in my opinion. So that's I guess the issue I would have with it is having people participate and, you know, offer under a volunteer lens their time and efforts to, you know, basically have the voice of that particular community or interest group that is listed in the statute, to have that heard by that individual who is essentially speaking on behalf of that group, and then basically telling them, oh, but you can't vote on it. Like that just seems very weird to me. Anybody else have any thoughts on it? Okay. Well, yeah, it's a good discussion. It's definitely something we can kind of keep our eye on. I think again, when they're specifically amending the statute that gives us, you know, our authority, I do think it's appropriate for us to talk about it. And again, if it gets to the point where, you know, enough of the membership feels that some kind of I don't even know, because again, we also have to contend with the department itself, because we are housed under the Department of Regulatory Agencies, and we have some specific, you know, legislative policies and such. So I'm recalling, you know, a letter they wanted to draft to the legislature back in 2022 that caused all sorts of panic within the department. I'm sure some of you remember that. So we'd have to use the right kind of approach is all I would say. But again, it's just going to depend on how the group feels about it. Yeah, Michael.
Well, so I was thinking that it also, just because of my conundrum about talking about my recommendation that the shared version, the shared expense version goes forward rather than the landlord only version, is that if we are recommending a shared version, say that there are something like statutory fees that can be charged to the person being towed as a disincentive for bad parking, so that not all of the burden is on the landlord. That if that were to happen, then it would automatically become under our purview to set those rates, as far as I can tell. So that's where it seems to me, if I can't talk to the bill sponsors or the drafters about that, that the towing task force really then needs to be the source of the input. So because of that, I would recommend that we actually put that on the table to discuss.
Okay, I see where you're coming from. I guess the way I look at it, when we're talking about whose responsibility it is to pay fees, I would imagine the towing carriers are still going to say they need to receive the same amount of compensation to meet their their costs and expenses and things like that. So, for example, whether or not I wish John Connolly was here. I'm sure he could chime in on this, but whether or not the property owner is paying the bill or the vehicle owner is paying the bill doesn't impact the cost of the diesel prices, for example. So that's part of it. That's part of where I'm leaning on it. But I'm not disputing that there may be some indirect impacts or ripple effects from them, going, as Mr. Schoenheit said, going under this more, paradigm shift of how towing works in the state, and actually based on my own research in many other states as well. I mean, I have yet to encounter a state where the vehicle owner isn't responsible for towing costs. Like, that's just the way it happens. It seems to be everywhere. So it's definitely a new concept that's being explored, and I'm very curious to see where it goes from where it is right now. But yeah.
Could I follow up real quick on that?
Yeah. Go ahead, Michael.
So the way I was thinking that the regulation would go is that there's part of this the current regulation where you can get your car back, but you have to pay for it. And right now you have to pay up to 15% of cost, right? And so the shared version of it would still require that you pay, say, the fee amount or the fine amount in order to get your car back. And if that's the case, then it seems to me that statute would then automatically loop us in as the task force that would set what those fine rates would be. So that's why I was thinking that would be slightly different, and it would still be within our purview by current statute. So that was just the follow up. And I see Ms. Henson has her hand up.
Yeah, I just have a couple of things is if the property owner pays for things, then at least the towing carrier gets paid. The problem with non-consensual towing and the new laws of the 15% or $60 is that we never get paid. So at least if the property owner, I believe, was responsible for it, then we would get paid. The problem I see with that is it holds no accountability to the person that misparked their car or was there without a permit. They don't have any consequences, so they keep doing the same thing over and over again. But the property owner usually does know more of who that person is, or if they were a tenant, they could charge the fees back to that tenant on their next month's rent. Or if it was a guest of that tenant, they could charge it to that next month's rent when we don't have the ability of doing that. So that's kind of, I see both ways. And I think the shared would be good. At least we would get paid something, even if we didn't get paid anything and they did a payment plan on their end, we would get paid something from the property owner. So I do see it both ways. I just wanted to chime in on my opinion on kind of where we stand over here and what I see.
Yeah, and you're not the first towing carrier I've heard make mention of the mechanism they put into the bill 2 years ago for. I've referred to it as the release without full payment provision. That's the whole 15% $60 mechanism. And I've heard from numerous towing carriers over the past year and a half about they get that 15% or $60 payment, but I guess collecting any kind of payment after the fact has been quite difficult. So
it's impossible. We've never actually been paid by any payment plan yet. We have never been paid by anybody.
All right. Yeah, and I think we're hopeful at the commission. I think we're hopeful that the new rules that unfortunately are still pending, but we're getting there. That once those go into effect, we did make some tweaks to that mechanism, not in any way that conflicts with the statutes, but in a way that kind of clarifies exactly how a towing carrier may go about collecting that additional balance after the fact. So we were working with TRPC and some other places to get feedback on the best things we could put into a rule without conflicting with the statute, to kind of make it a little more easy of a mechanism to use for the towing carriers. So that's something I know we felt pretty strongly about, and I think we got mostly what we need in there to make it a little easier on y'all to try to pursue that in a little more practical way. So hopefully that helps. Obviously the rules still aren't in effect yet, but once they are, I think that'll give some additional cover to approach that in an appropriate way. So that's still on the horizon. But yeah, no, I think you made a good point.
Okay,
Sure. All right. Anybody else have any other thoughts, Michael?
Well, I do have a question just about our purview with regard to rates at this point, which I'm curious now that a certain subsection of tows are to be paid by the landlord by contract, whether the standard fees and charge amounts even apply to those contracts. So are the prices that we're talking about, are those actually now pertinent to the landlord tower contract? Are those standardized now? And do the landlords have to pay a per tow fee that basically covers that is at the amount that the PUC sets, or is that actually open to discussion and to be determined on a per contract basis? So I'm just confused as to what the current rates are that we have recommendations over how those actually apply to the new scenario.
Right. Yeah, no, I get your point. I think the way I would respond to that is, the way the rates have always been, I guess, considered or defined at the PUC level is it's costs for services, so, whether they're, towing for this or towing for that, it's a price associated with a particular type of service that's being provided by the towing carrier. The other thing to think about is also the fact that it's put in by rule as a maximum charge. So basically, or a maximum rate. So basically, if you have, a particular type of tow, say a non-consensual tow from private property of a vehicle of such size and weight, then this is the maximum rate that you can charge. Now, there's nothing that has ever prohibited, at least as far as I can remember, that has ever prohibited a towing carrier from charging less than that. So say you had let's imagine a world where a property owner was responsible, and the towing carrier goes to them and says, oh, this is the maximum rate allowable by the state, and this is what we want to charge. But maybe the property owner comes back and says, well, I don't want to pay that. That's too much. So instead of the allowable $230 hook fee, we only want to pay you $200. And at that point, it becomes a negotiation, essentially. It's kind of how I look at it. So there's always that chance that you may start seeing more competitive based pricing under that maximum rate. That's always possible. I don't know how likely that is, but it's possible. Because again, we have always allowed our towing carriers to charge rates that are less than the maximum rates, if they so choose. And that's always been something that the towing carriers have been able to do, at least as far back as I can remember.
Yeah, but still the question is, do landlord tower contracts, are they governed by the maximum rates? So could there be greater rates charged?
Not greater. It's always
okay.
Yeah, not greater. And we've had that question come up over the years about, and in some cases, like I think way in the past that used to be allowable for certain types of tows, so like law enforcement order tows, for example. But I think for the most part, the better part of the last 8+ years or so, that's not been the case. It's basically you charge what we have put in the rules as the maximum rate. Like you can't go above that. You can go below that if you want, and some people do. So at that point, it basically just becomes a conversation between the property owners and the towing carriers to come to some kind of a middle ground. I think in most cases, especially with the property owner not being responsible, I don't think they had any trouble saying, being okay and on board with them charging whatever the maximum the state allows is. But, with that potentially being a shift, I could definitely see, the property owners wanting to haggle a little bit with what that price is.
Right. But again, to loop back though to the actual text of the law, and this is maybe too fine in the weeds, but the whole premise for the cap rates is that the person being charged was not consenting to the tow, right? And so that's the whole rationale for putting a max on that. Whereas if the landlord is now being the entity who's being charged, at least for the first 5 days now, then there's a question whether that maximum applies if it's whatever the contract is a consensual contract. So that's why I'm thinking that maybe there's some legal maneuvering room that would say why the fees would only apply to the person whose car was towed after the 5 days, and the rates would be pretty much open to any kind of contractual agreement for the first 5 days. That's again a question for interpretation of the actual text of the bill, especially with the rationale being based on the non-consensual nature of the tow.
Right. No, I understand what you're getting at. I guess I still just see it as, it's still a maximum rate that's going to apply based on the type of service that's being provided. And again, when we're talking specifically about non-consensual tows, I guess I'm struggling to see a situation where somehow that wouldn't apply, just based on something like, just because somebody else just happens to be responsible for that payment. But I mean, you raise a good point. And so, I think we can all look at that language if we're so inclined in the bill and kind of come to our own conclusions. But yeah, I guess I didn't really see this impacting much, the ability to still apply those same rate standards. So, but that's my thought. Okay. Anybody else have any thoughts? And Mr. Roberts, feel free to jump in if you think we're going a little too far outside of our bounds, but it all seems pretty reasonable discussion.
No problem.
Thank you. All right. Any other thoughts? We're about just coming up on 3:40 right now, so we've been going for a good hour and 40 minutes. Ms. Rusha.
Hey, I had to step out for a minute. I apologize. My aunt is really ill, but I came back in and I did you say, like, is there something for us to look at relative to the conversation that we were just having? I guess I wanted to chew on it a little bit.
So Dr. Pierce had raised some thoughts he was having on some pending tow legislation, which is House Bill 24-1051. And it does admittedly make some changes to our statute, which is the 4010.1403 in regards to voting standards and things like that for some of our membership. So that I think alone does kind of give us some latitude to discuss that bill. But I think mostly what we've been talking about is whether or not, at least through the lens of the Towing Task Force, does some of the ideas that bill is exploring potentially steer into what we're responsible for, which is making appropriate recommendations to the PUC on what the maximum rate should be for non-consensual towing, namely what the new concept of potentially making parties other than the vehicle owner be responsible for some of the non-consensual towing fees, whether or not that somehow steers into what we talk about and what we're responsible for. So that's essentially what we were just talking about.
Okay, and I apologize. I should have clarified. I did see, I saw the bill and I didn't understand. Maybe I just missed because I had to step out for a minute. The nexus of or maybe I just misunderstood. But I don't want to derail the I don't want to derail the conversation. The one concern that I have had, I just wanted to share, I'm sure this has been discussed, like when we talk about landlord being that party or being a responsible party, is just, how things can get passed on to the consumer. And I guess I actually don't even know if this is legally permissible. Mr. Riley, maybe you can tell us, but I do know there are situations in where the apartment complex or landlord or even HOA will charge a fee just because, but like, so they will have their own separate fee for like violating, you know what I mean, some parking regulation or because you got towed. And then like in addition to the consumer needing to pay to get their vehicle back if it is towed. So I think I just need to like chew on what I was thinking a little bit, and then maybe I'll send an email or bring it up in the next meeting. But I'm concerned that there might be like loopholes, you know, if the way we do, I don't know, if the if statute is like changed significantly and we don't consider that angle or put in those guardrails. Does that make sense?
Yeah, I get where you're coming from. It's basically the whole idea of, well, yeah, maybe the property owner is responsible for some initial set of fees, but can the property owner then turn around and through some other mechanism, you know, maybe through the lease or something else, essentially levy some kind of financial penalty of some kind that essentially is tantamount to the towing carrier charging them directly.
Right. And
so
potentially,
that-
oh, sorry, if I could clarify, and also potentially like not just like passing it through, like a pass through, but also an additional, you know what I mean? Surcharge, like additional. Does that make sense? Because
Sure.
I know like right now, like some landlords will charge a fine, you know, for parking violations on top of the fact that you might have gotten towed. And some will charge a fine if they had to call a towing company. I know it might be more common with HOAs, but and this has come up before a little bit, but I guess as I just think about, you know, the landlord being a responsible party or having a different role, I just wanted to bring that up from a consumer standpoint, you know. We'd hate to have a situation in which the car owner is potentially saddled with, you know, more fees or, you know what I mean, than the current system.
Yeah, no, I understand where you're coming from. And I think it would all depend on how the HOA bylaws or lease agreements were set up to see if that's even something they can do. But I do admit that does seem a little bit, I guess to me, it seems like that's swerving a little bit out of our lane, because now we're talking about what the property owner is doing in a property owner tenant relationship or something equivalent, whatever the HOA equivalent of that is. And so, yeah, that does seem a little out of our scope to me personally. But I don't think that would preclude us from being cognizant if that's something that is available through whatever paradigm shift they may want to go through with, you know, payment responsibilities and stuff like that. I don't know that it's something we are precluded from thinking about, but when it comes to like the practical application of, okay, how do we adjust our recommendations to the PUC based on that factor? Again, I think we just want to be careful not to go too far outside of our scope. Jenny, did you have something?
Yeah, I was just, I can't remember what I was reading, but I was reading something to that effect that it was saying that the landlords were charging tenants for a certain fee on their contract for the monthly fee of like they may have to call a tow truck out. So I have seen that, and I can't remember where I was reading that, but it did say something to that effect of, in that complex, you would pay a certain amount, and that would be for the patrol of people watching for people misparking, and then also for the signage, I believe, that the apartments pay for, and then a monthly fee. It's just kind of like an HOA fee, but it was on top of the HOA fee. It was like having a towing carrier on hand type fee. And I can't remember where I was reading that, but it was recently, and they were charging those fees or talking about charging those fees. But I don't know if that's in our area or if it's not. But I just remember reading that.
Yeah. Well, and again, while we have control, well, we don't technically have control, but while we have the ability to make recommendations to the commission on what we believe the commission should put into rule for maximum rates that non-consensual towing carriers can charge. So we do have some influence there. I don't know. I think it ends there, and I guess I don't see how it could extend to what the property owners are doing. And again, if that's something they build in to this new concept of who's responsible for what, then I don't know that we have much say over that. If that's something they're essentially building into the framework. Yeah, Michael.
Well, the main point that I wanted to make was again my conundrum about who I can talk to about recommending the shared version, and that's that all of these comments do bear on recommending a shared expense version of this, because it will become our purview. It seems to me to set the kinds of fines that can be charged to the towee, and so it seems like if we're recommending, or sorry, if we're talking, if any of us want to recommend that, and we can't because we're members of the towing task force, and it might come under our purview, it seems like we would need to do that as a towing task force and think about that as a recommendation, and that's how it becomes a part of our purview. And so in response to Joy, Ms. Rusha's comment and Ms. Henson's comment, my sense is that without enough disincentive to the bad parkers, that what's potentially going to happen is that there's going to be more bad behavior, and then the price of towing is going to go up for the landlord just because there isn't enough of a disincentive mechanism. And if they're going to pass that along, which they probably are, to tenants, then this bill is going to raise the overall cost to everybody. It's going to be broader, shared more broadly amongst tenants, but nonetheless, the total going out is going to be higher. And I also, it seems to me like for handicap parking spots, basically they're on private property, there's very little disincentive, and so it seems like we should be recommending that there be shared towing, at least to prevent the increase in bad behavior. And if we're recommending that, and we're recommending, if we think it should be in place and it's under our purview to regulate those rates, then that again seems to make it part of our function as a committee. So that's why I think it does. I think we can talk about it, and then that's how it loops in these kinds of factors for us.
Okay, Joanne.
Oh, thanks. So I think I was viewing it as like, who are the interested parties? And the landlord obviously is an interested party. And in a way, if you have like a contract between the towing, it might be a stretch to others, but this is how I was thinking of it. If you have a contract between the towing operator and the landlord, right, and the fees are, being shifted from the car owner, then I kind of feel like yeah, even if the fees aren't, like they're not direct towing fees, like they're like, it's like it could be potentially indirect. Does that make sense? And so that's why I guess that's why I was raising that, because even if we like shift a burden or a cost, it still has to be paid by someone. And in many cases, well, anyway, that was my thought process, and I think Dr. Pierce actually explained it better than I could. I think we're on the same track a little. I did want to get like, because I feel like I've heard two different things, like just a final word, maybe from you, Mr. Riley. Like, if individual members of the task force want to advocate, like as individual members, is that, I mean, are we saying that that's not permitted? Or just the task force as a whole has to stay in their lane?
Mr.
And at
Roberts,
this point, I think we should be playing transit bingo because we've made all, we're using all those phrases.
go ahead, Mr. Roberts.
Thanks, Ms. Rusha. I appreciate that. And I'm going to, just to give you a heads up, Nate, I'm going to throw it back to you about policy, but there's nothing legal. Sorry about that. I got two crazy dogs hanging out with me. There's nothing legally that prohibits board members, task force members from advocating for or against legislation. But like I said earlier, Dora and possibly the PUC have policies about what can be said and when you say it, when or not what can be said, but what you have to say is, I'm speaking on my about this on my own behalf, not as a member of X organization, not a member of the towing task force. So does the PUC have anything specific about that, Nate, or am I just thinking about a higher level Dora policy?
I mean, we take our cues from the EDO's office. So basically
Okay.
it's the department. So basically whatever, but I mean, I'm also coming at it, looking at it based on how you just described that. I'm looking at it through the lens that I see through as an employee of Dora. And so I know I have very tight reins on any kind of engagement with legislation just due to those internal department policies. I guess I'm a little unclear on how that potentially could extend to someone's role as a member of the towing task force. Because again, it seems pretty clear in the statute that our role as members of this task force is to, I guess, share our opinions through the lens of the specific community or interest group that we are charged to represent. And so that kind of makes things a little trickier, I guess. But yeah, I do remember that back in 2022 when HB 221314 was going through, there was plenty of members on the task force who wanted to like draft a letter to the legislature, and it was this whole thing that basically had to get tamped down because everybody was ready to march over to the Capitol and share our opinions on stuff, and the department essentially had to rein us in as a group and say, no, like that's not how this works. We're essentially still accountable to the department. And so because of that, I think, again, we would just have to tread very lightly and carefully on how we approach it. Now, I don't think there's anything that precludes us from going to the department and being like, hey, our intent is to raise, X issue in regards to pending legislation, and then see how they react. I don't think there's anything that would be wrong with handling it that way. But again, that's not how it was handled back in 2022. And so again, they had to really reel us back in as a group, back in spring of 2022 because of that. So I think we just want to kind of avoid that similar circumstance where, we want to pursue a certain action that may not be something the department allows us to do. Because again, at the end of the day, we are a board and commission that is housed under this department. So we essentially take our cues from them. So the annual training we just did today, for example, is something they told us to do. So we did it. It's the same concept. So I think we just want to make sure whatever we're doing is not conflicting with what the department is comfortable with. I think that's kind of my perception of it. John?
Yeah, thanks, Nate. So, Ms. Rusha, I saw your comment, and I think your second paragraph that if people are clear that they're not representing the views of the task force or of the PUC, I think that's an easier it's an easier argument to make that having, advocating for or against legislation is appropriate. And on something that Nate said, I think we have to be careful about what our charge is, and it's to recommend to the commission rates. It's not to respond to interest groups or the industry or anybody else. So our statute defines what this body is charged with, and therefore what its scope is. I just want to make sure that we remain clear on what the law gives to us to do.
Okay. All right. Well, I think we've definitely gone through a lot today, and it's definitely plenty to digest. Just to revisit a few things really quickly, because we are coming up on time here, and I want to be respectful of everybody's schedules. But just a reminder, I think we are going to go ahead and schedule our next meeting for March 13th. So it'll be 2 weeks from today, same start time, 2 p.m. That should get us back on our regular schedule track of every second Wednesday of the month. Again, that's what we've been doing for the last 2 years, and it's seemed to work well with people's schedules. So again, if everybody can kind of anticipate that, I think we maximize our chances of having as many people participating as possible. Hadija, if you could make a note, next meeting 3/13, 2 p.m. And we'll go ahead and send an invite on that probably sometime before the end of the week. So keep an eye out on that. Again, we do communicate pretty much solely through your state email or your state issued email addresses. So be sure you're checking there periodically. We have kind of made a habit of sending out 2 week and 1 week reminders. Since we're right at the 2 week before our next meeting, we'll probably just send out a 1 week reminder, but we'll try to include copies of the minutes and agendas and that kind of stuff. So we'll try to stay on top of that as much as possible. It might be a little difficult to get the minutes turned around that quickly. So before our next meeting, it might be right up against when that meeting is on the 13th. But and again, just welcome to our new members. Thank you for participating. And our reappointed positions. Thanks for continuing to participate in these meetings. Thank you everybody for coming today. Again, we'll also be circulating those affidavits for the training we took today. If you weren't here today, my understanding is you could just watch the meeting recording and be privy to all of the substance that was in the training that we shared today. As Mr. Roberts mentioned, he's available for questions if you have any. So go ahead and watch that training, and you can sign that affidavit as well. And we'd ask for a quick turnaround on those. Would be much appreciated. If you have any questions, just let us know. All right, we're right about time, coming up on 4 p.m. So appreciate everybody's patience in staying the whole meeting. Definitely appreciate that. And just keep an eye out on that state issued email address. You'll see some emails coming out from Hadija for the next meeting and some other things. So keep an eye out for that. And otherwise, thanks everybody for attending today, and have a great rest of your week. Thanks everybody. We're adjourned.
Thank you.